Practice and EA requirements, video 1 of 2. The Office of Professional Responsibility generally has responsibility for matters related to practitioner conduct and exclusive responsibility for discipline, including disciplinary proceedings and sanctions. The Return Preparer Office is responsible for matters related to the issuance of PTINs, acting on applications for enrollment, and administering competency testing and continuing education for designated groups. Practice before the IRS is covered by Circular 230 and involves matters relating to any of the following: communicating with the IRS on behalf of a taxpayer regarding the taxpayer's rights, privileges, or liabilities under laws and regulations administered by the IRS, representing a taxpayer at conferences, hearings, or meetings with the IRS, preparing, filing, or submitting documents or advising on the preparation, filing, or submission of documents, including tax returns, with the IRS on behalf of a taxpayer, providing a client with written tax advice on one or more federal tax matters. Any individual may, for compensation, prepare or assist with the preparation of a tax return or claim for refund, appear as a witness for a taxpayer before the IRS, or furnish information at the request of the IRS or any of its officers or employees. Who can practice before the IRS? Certain individuals are subject to the regulations contained in Circular 230. However, any individual who is authorized generally to practice must be designated as the taxpayer's representative and file a written declaration with the IRS stating that he or she is authorized and qualified to represent a particular taxpayer. Form 2848 can be used for this purpose. So even if a person is able to practice before the IRS, to represent a particular taxpayer, there needs to be a written authorization and Form 2848 can be used. So here are certain individuals who can practice before the IRS. Appraisers. Appraisers have no representation rights, but may appear as witnesses on behalf of taxpayers. Attorneys. Any attorney who is not currently under suspension or disbarment from practice before the IRS and who is a member in good standing of the bar may practice before the IRS. Certified public accountants, CPAs. Any CPA who is not currently under suspension or disbarment from practice before the IRS and who is duly qualified to practice as a CPA may practice before the IRS. Enrolled agents. Any enrolled agent in active status who is not currently under suspension or disbarment from practice before the IRS may practice before the IRS. Enrolled retirement plan agents, enrolled actuaries, low-income taxpayer clinic student interns. Under certain circumstances, a student who is supervised by a practitioner may request authorization to represent a taxpayer before the IRS. Unenrolled return preparers. Unenrolled return preparers may represent taxpayers only before revenue agents, customer service representatives, or similar officers and employees of the IRS, including the Taxpayer Advocate Service, and only during an examination of tax returns they prepared and signed before December 31, 2015. If an unenrolled preparer does not meet the requirements for limited representative, taxpayers may, in any event, authorize the unenrolled return preparer to inspect or request tax information by filing Form 8821. Simply, the inspection or request for information is not the same as practice before the IRS or representation of a taxpayer. Annual filing season program record of completion. Only unenrolled return preparers with a valid PTIN who hold a record of completion for both the tax return year, 2015 or thereafter, under examination, and the year the examination is conducted may represent under certain conditions. So they need to hold a record of completion for both the tax return year, and the year the examination is conducted. Those unenrolled preparers who have annual filing season program record of completion may represent under certain circumstances. Because of their special relationship with the taxpayer, the following individuals may represent a specified taxpayer before the IRS. An individual can represent himself or herself before the IRS, a family member, a bona fide officer of a corporation on behalf of the corporation, a general partner on behalf of the partnership. A regular full-time employee can represent his or her employer. Note that a fiduciary, such as a trustee, stands in the position of a taxpayer and acts as the taxpayer, not as a representative. In general, individuals who are not eligible or who have lost the privilege as a result of certain actions may not practice before the IRS. If an individual loses eligibility to practice, the IRS will not recognize a power of attorney that names the individual as a representative. Who may not practice before the IRS? In general, individuals who are not eligible or who have lost the privilege as a result of certain actions may not practice before the IRS. If an individual loses eligibility to practice, the IRS will not recognize a power of attorney that names the individual as a representative. Corporations, associations, partnerships, and other persons that are not individuals cannot practice before the IRS. Generally, individuals lose their eligibility to practice before the IRS in the following ways. First, not meeting the requirements for renewal of enrollment, such as continuing professional education. Next, requesting as an enrolled agent to be placed in inactive retirement status. Next, being suspended or disbarred or determined ineligible for practice by the Office of Professional Responsibility for violating the regulations contained in Circular 230 or the standards in Revenue Procedure 81-38. Next, losing their state license to practice as an attorney or CPA, irrespective of the basis for the license revocation. Enrolled individuals and AFSP record of completion holders who fail to comply with the requirements for eligibility for renewal will be notified by the IRS. The notice will explain the reason for ineligibility and provide the individuals with a time-sensitive opportunity to furnish information for reconsideration. An enrolled individual will be placed on the roster of inactive enrolled individuals for a period of 3 years if he or she, first, fails to respond timely to the notice of noncompliance with the renewal requirements, or fails to file timely the application for renewal, or does not satisfy requirements for renewal. The enrolled individual must file an application for renewal within 3 years and satisfy all requirements for renewal after being placed in inactive status. Otherwise, at the conclusion of the next renewal cycle, he or she will be removed from the roster and the enrollment status will be terminated. Enrolled individuals who request to be placed in an inactive retirement status will be ineligible to practice before the IRS. They must, however, continue to adhere to all renewal requirements. They can be reinstated to active enrollment status by filing an application for renewal and providing evidence that they have completed the required continuing professional education for the enrollment cycle. All individuals practicing before the IRS are subject to disciplinary proceedings and may be censured, suspended, disbarred, or monetarily penalized for violating any regulation in Circular 230. This includes engaging in acts demonstrating incompetence or disreputable conduct. Practitioners who are suspended or disbarred in a disciplinary proceeding are not allowed to represent taxpayers before the IRS during the period of suspension, disbarment. A practitioner can seek reinstatement from the Office of Professional Responsibility at the earlier of a specified period of suspension or after 5 years of disbarment. The earlier of a specified period of suspension or after 5 years. Rules of practice. The rules governing practice before the IRS are published in Circular number 230. Practitioners have a duty to perform certain acts and are restricted from performing other acts. In addition, a practitioner cannot engage in disreputable conduct. Any practitioner who does not comply with the rules of practice or who engages in incompetent or disreputable conduct is subject to disciplinary action. Also, unenrolled return preparers must comply with the rules of practice and conduct to exercise the privilege of limited practice before the IRS. Again, unenrolled preparers must comply with the rules of practice and conduct to exercise the privilege of limited practice before the IRS. There are 2 specific sets of rules that apply, both contained within Circular 230. First, duties and restrictions relating to practice. That's subpart B of Circular 230, and conduct considered to exhibit incompetence or disrepute. That's subpart C, Section 1051 of Circular 230. Prompt submission of records or information. Individuals subject to Circular 230 must promptly submit records or information sought by a proper and lawful request from officers or employees of the IRS, except when the practitioner believes on reasonable grounds and good faith that the information is privileged. Communications with respect to tax advice between a federally authorized tax practitioner and a taxpayer generally are confidential to the same extent that communications would be privileged if it were between a taxpayer and an attorney. This is relevant if the advice relates to either non-criminal tax matters before the IRS or non-criminal tax proceedings brought in a federal court by or against the United States. Duty to advise and general due diligence. An individual subject to Circular 230 who knows that his or her client has not complied with the revenue laws or has made an error or an omission in any return, document, affidavit, or other required paper has the responsibility to advise the client promptly of the noncompliance, error, or omission and the consequences of the noncompliance, error, or omission. So the requirement is not to advise the IRS. The requirement is to advise the client of the noncompliance. Individuals subject to Circular 230 must exercise due diligence when performing the following duties: preparing or assisting in the preparing, approving, and filing of returns, documents, affidavits, and other papers relating to IRS matters, determining the correctness of oral or written representations made by him or her to the Department of Treasury, or determining the correctness of oral or written representations made by him or her to clients with reference to any matter administered by the IRS. Reliance on others, delay, and assistance from disbarred or suspended persons. A presumption that due diligence has been exercised will apply in situations where there has been a reliance on the work product of another person if reasonable care was used in engaging, supervising, training, and evaluating the person, taking proper account of the nature of the relationship between the Circular 230 individual and that person. Individuals subject to Circular 230 must not unreasonably delay the prompt disposition of any matter before the IRS. Individuals subject to Circular 230 must not knowingly, directly, or indirectly do the following: accept assistance from or assist any person who is under disbarment or suspension from practice before the IRS if the assistance relates to matters considered practice before the IRS, or accept assistance from any former government employee where provisions of Circular 230 or any federal law would be violated. Negotiation of refund checks. Individuals subject to Circular 230 may not endorse or otherwise negotiate any check, including directing or accepting payments by any means, electronic or otherwise, into an account owned or controlled by the practitioner or any firm or other entity with whom the practitioner is associated. So, may not endorse or otherwise negotiate any check issued to a client by the government in respect of a federal tax liability, and that includes any by receiving payment by any means. Censure, disbarment, and suspensions. The Secretary of the Treasury or delegate, after notice and an opportunity for a proceeding, may censure, suspend, or disbar an individual subject to Circular 230 from practice before the IRS if the individual is shown to be incompetent or disreputable, fails to comply with the regulations, or with intent to defraud, willfully and knowingly misleads or threatens a client or prospective client. Censure is a public reprimand. Let's look at some questions. Mike is an enrolled agent. For the past 5 years, the information that Ann provided Mike to prepare her return included a Schedule K-1 from a partnership showing significant income. However, Mike did not see a Schedule K-1 from the partnership among the information Ann provided to him this year. What does due diligence require Mike to do? Without talking to Ann, Mike should estimate the amount that would be reported as income on that K-1? No, that wouldn't be appropriate. Just simply estimating the amount on the presumption that there is income, that wouldn't be appropriate. Call Ann's financial advisor and ask him about Ann's investment. Well, not necessarily the first step. If Ann approved it after speaking with Ann, that may not be a bad step, but that's certainly not Mike's first step. Nothing, because Mike is required to rely only on information provided by his client. Well, that's not appropriate either, because for the past 5 years, Ann has always had the Schedule K-1. That necessitates that Mike do his best to determine her tax liability, and that would be to ask about that K-1. And then finally, Ask Ann about the fact that she did not provide him with a Schedule K-1. That is absolutely the best answer. Absolutely the best answer. Who is authorized to practice before the IRS if they do hold a power of attorney? Any person considered an enrolled agent under Circular 230 who's not currently under suspension or disbarment, who holds a written declaration? Sure, that's fine. Any attorney who's not currently under suspension or disbarment from practice before the IRS who has a written declaration? Absolutely. So both A and B are authorized to practice before the IRS. Yes, definitely. They're not their enrolled agent or attorney. They're not currently under suspension or disbarment, and they hold and file a written declaration that they're qualified and authorized to act on behalf of the client. Absolutely. Both A and B is our answer. And then finally, the Office of Professional Responsibility can censure, suspend, disbar a practitioner from practice. Which one of the following is disreputable? Being indicted for any criminal offense under revenue laws? Well, indictment is not enough. We need conviction. So that is not disreputable conduct. Having a motor vehicle license suspended for traffic violations? No, even though there may be convictions in that case, simply traffic-related violations would not be pertinent enough to the work that a practitioner does to necessitate or to be considered disreputable conduct. Being indicted of a felony under federal or state laws that for which the conduct involved renders them unfit. Well, again, indictment is not enough. Giving false or misleading information or participating in any way of giving false or misleading information, Department of Treasurer or any officer, yes, that is disreputable conduct. That is giving false or misleading information to IRS or Secretary of Treasury, but by and large, that means the IRS. Yes, that would be disreputable conduct. That would be our answer. Letter D there. All right. Well, I hope you found this helpful. This is part 1 of 2 under practice and EA requirements as you prepare for part 3 of the enrolled agent exam.